everyone. We have honestly some of the Zoom and Learns that I look forward to the most with attorney Brandon McGee with McGee Law Firm. I've learned so much even about my own situation and what to do with my family and my aging parents. I love these. I take something away every time. Brandon is extremely learned, however you prefer to say it, and what he talks about. And today's topic is what to do when a loved one passes. Now, this apparently was a popular topic. We had 125 people registered for today. So thank you very much for joining me, Zoe Frost and Celebration Magazine Live, and Brandon McGee with McGee Law Firm. I'm going to turn it over to Brandon. Brandon, take it away.
Okay, thank you so much, Zoe. Mitch is going to help me here get the split screen up so that you guys can hopefully see me and the slide presentation all at once. So bear with us here briefly.
Looks great.
So hopefully we're in good shape here. So as Zoe said, we are going to discuss what happens when a loved one dies. And first off, I want to thank all of you guys for being here. We're happy to see the response. Obviously, this is we're not dealing with a happy subject matter, but we're dealing with a realistic subject matter that it's much better to know ahead of time and be prepared ahead of time than to be caught off guard when things like this happen. And so I'm going to take you guys through this, and we're going to talk about estate planning. We're going to talk about probate. We're going to talk about the different ways that things can be done to handle things like passing down assets when a loved one passes away. Okay. So a little bit about myself first, so that you have a sense of my background and why I'm qualified to talk to you, and why you should be listening to me about this topic. I think that's important. So I'm a DFW native, kind of a rare breed, I think, these days. We've had so many folks move in from all over the country and the world, the last 10 to 20 years, but born and raised here. I went away to law school. I journeyed to Atlanta, Georgia, where I went to Emory University School of Law, then came back to Texas, and I've been practicing since 2002. Accidentally bypassed my undergraduate career, which I greatly enjoyed. I'm a TCU Horned Frog. So I went to TCU in Fort Worth for undergraduate. I'm also a member of the American Academy of Estate Planning Attorneys and the National Academy of Elder Law Attorneys. Now, briefly, the American Academy of Estate Planning Attorneys is a long-standing national organization. We are not an organization that any attorney who wants to can join just because they write a check. We are highly vetted. We are limited by region. We have attorneys all over the country, but only a certain amount per region. At the moment, I'm very fortunate to be the only DFW member, although we have several other Texas members in other cities. And the American Academy gives me a lot of great resources, great attorneys to network with. And the thing is, when you are working with an academy attorney, listening to an academy attorney, what you know is that this is what we do. We are not a law firm or an attorney who practices 4 or 5 different areas of law, and this just happens to be one of them. This is what we do day in and day out. It's what we love and enjoy. Also, NALA, National Academy of Elder Law Attorneys. Now, let me be honest. This is one where if you're an attorney and you want to be in the organization and you cut a check, they let you in. But it's a great organization nonetheless. A lot of great practitioners across Texas and the U.S., and they also help keep us up to date on current trends in elder law. We're also a member of the Better Business Bureau, where we have an A+ rating. And let me just tell you guys real quick too, I kind of forgot, I should mention this. I have 2 offices in DFW, and it's my only 2 offices are in DFW. And we have a South Lake office and we have a downtown Fort Worth office. However, we do represent clients from all over the metro area, and I actually have clients to some degree from all over the state as well. But primarily my clients are, the vast majority are here in DFW. So you'll see my family here. This is my wife, Rita, who is a fee attorney with Capital Title. You'll see our fraternal twin sons, Cole and Hunter. Yes, they are twins. And so why am I an estate planning attorney? I think to address this quickly, it's an important question. Because there's a lot of different things I could be doing. And so when I was in law school, when I was getting out of law school, when I was a young attorney, if you had told me that I was going to be an estate planning attorney, I think I would have, fallen down and been real sad and, maybe cried. I would have thought that sounds really boring. I don't want to be an estate planning attorney. I want to be a trial attorney. I want to be in the courtroom with all the excitement and the fireworks. And so that's what I did. For a number of years, I was a trial attorney. For a number of years, I really enjoyed it. It was exciting. There were a lot of fireworks. But as I got married, had my own kids, and started raising my own family, I started to get burned out on it, to be honest. The stress of the trial attorney, some of the long hours, things that kind of take you away from your family, things that cause you to not be in a great mood around your family sometimes when you're at home either. And so I started thinking that I just lost the enjoyment for this, started thinking about other things I could maybe do. Well, in 2012, so this was almost 9 years ago exactly, pretty close, in May of 2012, my wife, Rita, was diagnosed with stage 3 breast cancer. And so for those of you who have been through this diagnosis yourself or with a close family member, especially, and not to minimize it happening to those of us who are, older in age, but especially when it happens to somebody in their 30s and you've got young kids, it was just an absolute shock to the system, right? It was the last thing in the world we were expecting to have happen. And it did happen to us. And so there you are, but having to deal with it. But Rita immediately started going through chemotherapy in late May of 2012. And 35 days later, my father, at the age of 64, died in his backyard in Dallas, July 1st, 2012, in his backyard working in Dallas, Texas, of a sudden and massive and completely unexpected heart attack. It was one of those here one moment, gone the next events. This is 35 days after my wife's diagnosis. And so that year of 2012 caused me to do a lot of soul searching. And what I realized was that I was going to work every day. And I had been for a while, not very happy, not excited to get in the office and be a part of my career. And I decided coming out of that year that, life can be short. We should get up every morning and enjoy what we do. And I had a smaller part of my practice that was estate planning and probate. And I decided that I was going to convert my practice to exclusively estate planning and probate because I really enjoyed the estate planning. And the reason I enjoy estate planning is because, to me, it is preventative law. Just like we have preventative medicine, we have preventative law. And that's where we know that things are going to happen. People are going to pass away. People are going to go into nursing care. People are going to become mentally incapacitated. There are things that we can do, though, for our families so that we are set up so that when these things do happen, our family or ourselves, if it's our spouse or our parent who has the problem, that we have the easiest road possible to travel down. And so rather than dealing with these absolute train wreck disasters and litigation, I started focusing on helping families set up to avoid train wrecks. And so that came out of that terrible year for myself and my family, was that decision. It ended up being one of the best decisions I've ever made. For me and my staff, we just really enjoy what we do. We love our clients. We love helping them set things up. And the best news of all is my wife, Rita, has been 8.5 years, no evidence of disease. And the kids are doing well. So that's the best news. Okay, enough about me. Let's talk about what happens when a loved one dies. So you guys also, please write your questions down. At the end, we'll do a Q&A. But please, and I think you're on mute anyway, so you can't blurt your questions out anyhow. But but please just write them down, and we'll do a Q&A at the end. I'm happy to do it.
Yeah, just put all your questions in the chat, even as they come up along the way, and then we'll review them at the end.
There you go. Perfect. But yeah, go ahead and put them in the chat. So what is estate planning, first off? Because when a loved one passes away, the first thing that I ask when somebody comes into my office and says, hey, my husband died or my mother died, the first thing I ask is, do they have an estate plan? And so that can be a last will and testament. That can be a trust, either revocable or irrevocable. That can also just be beneficiary designations where we're leaving direct beneficiaries to financial accounts and things like that. That's for people passing away. We also have powers of attorney. Now understand, powers of attorney are for somebody who becomes mentally incapacitated. They don't apply once you pass away. They only apply if you become mentally incapacitated. So an estate plan is basically, we have legal documents where we're preparing to pass down our estate after we pass away, and where we're preparing to appoint other people to be our decision makers if we should need that because we lose our mental capacity. At the end here, we have a little blurb about special needs planning. That is if you have a child or a grandchild who you want to leave assets to, but they are special needs and maybe potentially on Social Security, disability, and Medicaid, certain things that we need to do for those beneficiaries so that they don't lose out on those benefits that they're getting from the government that they're probably going to need for the rest of their lives, okay? We also look at Medicaid planning, and this is basically, we'll also call it Medicaid / long-term care planning. That's just not one of the big three things we want to look at in estate planning is if you have to go into a nursing home, how are we going to pay for it? So a lot of you guys probably have some awareness of this. It's becoming very expensive. It's a big business. There's memory care units, assisted living, nursing homes just popping up everywhere. And it's because there's a huge demand for them and they make a lot of money for the companies that own them. So that's another thing that we look at here at our firm is exploring that. But that is a seminar for another day. So let's talk about this. So now we're kind of getting into the meat of the matter of when a loved one passes. We're generally going to be doing one of two things. We're either going to be going to probate court or we're going to be doing a trust administration if the person left behind a trust. Now, understand this before we get into probate. If somebody leaves behind a trust and it is fully funded, which means that all of their assets are held in trust, all the assets are connected to the trust, that family gets to completely bypass the court system, period, end of story. It becomes usually a much quicker, cheaper, and less stressful route than the families that have to go through probate court. Now, I represent both families. I set up trust for families. I'll help do the administration if a client needs it. And I also take through the probate court system the families who have not set up to avoid it. And so I feel like I'm in a very unique position to advise on this, and to set up an estate plan that avoids probate is always less expensive in the long run, quicker, and less stressful in the long run, okay? That being said, there's a whole bunch of families out there that don't do that. Doesn't mean they're bad, it doesn't mean anything particularly negative. It just means that their family is gonna have a more difficult time getting title to their assets. And so ultimately what we're trying to do is this: when somebody passes, let's just keep this real cookie cutter. Let's say they have a house, a homestead, they have a car, and they have 2 bank accounts, and they have a 401k. We are trying to convert ownership of all those titled assets to the proper beneficiary. So if it's the spouse, we need to get those assets in the name of the spouse. If it's the kids, we need to get those assets in the name of the kids. If you don't have your estate set up to avoid the court system, then when your loved one dies, you're going to find yourself going through the probate court, okay? And you'll be going through the probate court in the county in which the person lived. And it doesn't matter where they die. It doesn't matter if they own property in Travis County and they died in Harris County, but if their primary place of residence was Dallas County, let's say, the probate is out of Dallas County. And basically what we're going to do is hire an attorney, go through the court system so that the executor or the administrator will be in a position to then sell the house, to then go to the company that holds the 401k and access those funds and basically liquidate all of the assets and distribute them to the beneficiaries, okay? So that's ultimately what we're trying to do. Like I said, if you have a trust, you don't have to worry about going through the court system. You just automatically do that as soon as the person passes. Okay. So again, probate is simply a way that we can get judicial authority from a judge. For me, if something happens to my mom and she leaves behind a last will and testament, I need a piece of paper from a judge, from the court, saying to Bank of America, saying to Charles Schwab or Edward Jones, I have the right to be here and I have the right to access this individual. This individual has passed away and I have the right to access all of her accounts and liquidate all of her accounts. Or to say to the title company, I have the legal authority to be at this table selling this property to the buyer. Okay. And so probate is the process in which the court gives us the authority to do that. Now, there's two different ways we can go through the probate courts, and I'm probably getting ahead of myself in the slides, but that's okay. We'll reference them and move on. But two different ways. If you do find yourself in probate court after a loved one dies, you want to really hope they have a last will and testament. Okay. And not only do we want to hope that they have a last will and testament, we want to hope that it's in very good shape. To be blunt, we want to hope that it's been drafted by an attorney. We want to hope that it's been drafted by a Texas attorney. And we want to hope that at least in the last 10 years, actually I'll say 5 to 10 years, it's been reviewed. And if any amendments or modifications were needed, those were made. But if you have a last will and testament, it's in good shape. It passes the legal criteria for the state of Texas. You're going to go through the probate court in a manner that is the quickest way, the cheapest way, and the less stressful way to go through court. Now, it's still more expensive and more stressful than not going to court, but it's the best way to go through it. I tell people, if you don't really like your family and you want to punish your family from the grave, don't leave behind an estate plan. Don't leave behind anything. Make them go through the court system without a last will and testament. This is very expensive. It is very time consuming. It is very stressful. The court can get very micromanagerial with what you can do and what they require, kind of the mother may I approach of you have to ask the judge to do this, you have to ask the judge to do that, very little independence. It also opens the doors potentially to bad major league bloodbaths between family members. So that's another thing that we unfortunately see with the families who either don't plan or don't have a good thorough plan or have an old outdated plan that doesn't take into account current reality. We see some bad family bloodbaths. And so the last thing we want our death to do is to cause our adult children to hate each other, right? And to get in a big argument. So at least have a last will and testament. If nothing else, if you get nothing else out of this today, you want to, at a minimum, leave behind a very good, comprehensive last will and testament, fairly recent, fairly up to date, drafted by a Texas attorney. Okay. Again, purpose of probate is to change title to assets. Now, a lot of people say, well, so the husbands, we always think we're going to die first. So the husband says in my office, well, when I die, I mean, she just gets everything, right? She doesn't need to do anything. I mean, the will says she can have it. She doesn't have, and we're married. She doesn't have to do anything. That is absolutely not true. Even the spouse, because we have community property in Texas, is going to have to go to court, and you're going to have to get your deceased spouse's name removed from the real estate, have your name put in title exclusively if you ever want to sell the property, or if you want to pass it down to your children without it being a big nightmare where they have to do a double probate. Same thing with particularly retirement assets, any individually titled assets, especially retirement assets. Where the spouse has to have a legal basis to go in and get access to those. You can't just show up, at the office of, Edward Jones or Fidelity and say, I'm the spouse, give me all the money. Unfortunately, it doesn't work that way. A lot of people think that it does, but it doesn't. Okay. So that's the purpose of probate. If things are not otherwise set up to avoid it, then we're going through the court to get that permission to change title to assets, to access assets. We're also going to resolve creditor claims and resolving disputes regarding the estate. Now, guess what? If you leave a trust behind, there's a reasonable chance and opportunity you can avoid all of this. You can avoid creditor claims, potentially. You can avoid disputes, potentially, and you can avoid, obviously, the court system. So the probate process, this says 60 to 180 days. 60 is fast these days. I think it's more, 120 to 180 day process now. But just because the courts are getting busy. But so the way it works is the client comes in, they hire us. We file an application to probate the will, or to probate the estate if there's no will. Month or two down the road, if there's a will, we have a hearing where the executor is finally appointed by the court to go do the job, to sell the house, to access the bank accounts. We have to send a notice out to all interested parties. These are all the beneficiaries are entitled to notice that this will has been probated. All the creditors, the known creditors of this person, of the deceased person, are entitled to notice so that they can come into the court system and try and get paid back. Okay, another reason to have a trust, you don't have to do that. At the end, towards the end, we have a final inventory of assets filed with the court. It's like an accounting. It is public record, and it's going to have all of your estate, the values, your debts, the amounts of the debt, all public record for anybody to access. So that's another reason we like to avoid probate if we can, is to avoid all of our family's information being public record. There can be some assets that are not subject to probate. And whenever I sit down with the client, my goal is generally to accomplish this. But assets in joint tenancy with rights of survivorship, we don't use that a lot in Texas, okay? But it exists. Assets held in trust. That is one key way to avoid things. Assets that have a beneficiary, another big key way to avoid probate court. We can beneficiary designate our automobiles with an in-house form through the Texas DMV. We can beneficiary designate all of our financial accounts just by requesting that from our financial institution. Also, we can now do transfer on death deeds for real estate, where we can leave behind a death beneficiary for our real estate. And that's relatively new in the state of Texas. Assets subject to probate, anything that's titled that was not otherwise set up to avoid it. So any and all real estate, banking and financial accounts, stocks, bonds, personal property is kind of a gray area. If there's a big dispute about it, it needs to go through the court system if it's not otherwise addressed in a trust. If there's not a dispute, nobody really cares. You just kind of split it up, but sometimes there are disputes about it. Also, something that's not on here, titled automobiles and vehicles. So boats, trailers, motorcycles, RVs, cars, those can be subject to probate if you don't otherwise set up to avoid it, okay? So anything that carries a legal title, if it's not set up to avoid probate ahead of time, it will have to go through probate court before it can be transferred to the beneficiaries. So when is probate needed in Texas? To keep it real simple, if you have a titled asset that does not have a beneficiary designation or is not held in trust, you need to go through probate to get to it, whether it's a car, a bank account, a piece of property, okay? So real property, bank accounts, etc. Anything titled that's not set up to avoid the court system, you're going to have to go through probate. What about a power of attorney for the deceased? This is real important to remember. I want all of my clients to have a power of attorney. It's very critical in my opinion. We recommend getting new ones about every 5 to 6 years, and because of how quickly the laws can change. We also recommend, if you're Texas based, having them drafted in Texas. But once somebody, let's take my family, for example, if something happens to me and I'm mentally incapacitated, I'm in a bad accident, and my wife is acting as my power of attorney, and she is using that to access my bank accounts, sell real estate, manage things financially for me, and then I pass away. The moment that I pass away and that she becomes aware of it, the power of attorney dies with me. So you are not supposed to use a power of attorney after somebody passes away. If you knowingly use a power of attorney after somebody passes away, there are potentially criminal and civil implications. So don't do it. Just remember, the power of attorney dies with the person, okay? Now, who's the executor? The executor is going to be under a last will and testament, the person left behind to handle the estate. So it's who John Smith says, my wife, Betty Smith, is my first choice if she survives me. My son, John Smith Jr. is my second choice if he survives me. If Betty is still alive when John passes, then she's the executor. That's who is going to, again, be appointed under the will to handle the estate. Now, who's an administrator? An administrator is when we go through the probate court and we don't have a last will and testament. The person that emerges as the court's choice to handle the estate, to liquidate the estate and to distribute the estate will be called an administrator rather than an executor. Okay, and this is where we can really see bloodbaths sometimes. And I'll say this, and it can be in a nuclear family. I've seen plenty of bad situations in a nuclear family, but in a blended family in particular, it is just a lightning rod for problems. If you do not have good comprehensive planning, and we've got step parents and step kids, sometimes the harmony is there, and oftentimes it's just not, and it may not even be there may be some dislike, or it could just be kind of an apathy, and people never really got to know each other well. And you have these step kids, they have no idea who their step brothers and sisters are. They met them once, and so this can become a real bloodbath for blended families in particular. When we have to have an administrator appointed, when we're deciding who's going to get what out of the estate, but it can happen in nuclear families as well. I've seen that numerous times. Basics of probate, some common terms. Independent administration is what we want. And that's going to happen when there is a properly drafted last will and testament naming an executor, and that gets through probate. And the administrator can be independent. They can just go do their job. They don't have to turn around and ask the judge for permission every time they want to do something. Okay. So we want to set things up. If we're going through the court system, we definitely want to fall under the independent administration category. Okay. Some things here I've already said, right? We're going to probate in the county where the person had their primary residence. It's not about where they die. It's not about where they owned a lake house or a condo at the beach. It's about where their primary residence was. Okay. Also a note here, when someone dies without a will in Texas, the default provision in the law requires that the estate be subject to a dependent probate administration. So that's why I said, if you die without a will, there's numerous hardships involved in this. One of the hardships is that your administrator is going to be dependent. They're going to have to jump through a lot of hoops for the court. It's real stressful. It's expensive. It's just not worth it. It's better to have something put in place. Another thing too, I just want to mention, popped in my head. From the time somebody passes in Texas, you have 4 years to probate their estate, to probate their will, or to probate their estate if they don't have a will. So you need to get this done within 4 years, or you can have very significant problems. Okay, so don't wait too long on this. That happens all the time for some reason that I can't figure out, but it does. Probate process, the application is filed with the court. We actually kind of talked about this already, but go through the process of filing the application, going to court, getting the person named executor, getting the letters testamentary, and then that person going and doing the things they need to do. In the meantime, we're noticing creditors, noticing beneficiaries, things like that. Things that just have to be done right in life. When somebody passes away, we have our inventory and our accounting that we're sending to the courts. We have to do taxes. Taxes are due 9 months after the person passes away. So we have a tax return for the year the person passed away, an income tax return. Even if they died on January the 3rd, you still have to do it for that year. And then we also have the estate tax return, just reflecting that this is the final return of the estate. So both of those need to be done. I recommend working with a CPA. They can get that done relatively easily. Okay. Now creditors, again, secured creditors must get a notice. Unsecured creditors get a publication notice. So we there's a paper called the Commercial Recorder, and that's where a lot of the probates get published. And every time somebody passes away here in DFW, everything regarding their name and the probate gets put in the Commercial Recorder. And the major creditors here in the US, they all enter that into their database, and they see if they have any hits for somebody for a name that owes them money. And then they enter into the probate and do what they can to get paid back. So if you're going to go through probate court because you didn't set up your estate to avoid it, your family's going to have to deal with whatever creditors you may have out there. When dealing with creditors, our estates code here in Texas, which controls probate and estates, they have a priority for payment. You can see it right there. Expenses of administration is number one. We go down to funeral expenses, debts and taxes under federal law, debts and taxes under Texas law, Medicaid recovery, so everything else. So we have a hierarchy if we're dealing with limited funds of who gets paid back. Intestacy statutes, this is when a person dies without a will. It's called dying intestate. Like I said, it's the worst thing you can do by far. Let me tell you this, let me just cut to the chase on this one right here. If you're a blended family, I deal with it, I swear, like 2 or 3 times a week, I get a call or I talk to somebody about this. If you're a blended family and you don't leave behind an estate plan, or your spouse doesn't, let's say you're the wife and your husband, who's a second marriage, he has kids from his first marriage, and he passes before you and you all have done no estate planning, your stepkids now own 50% of your house. You own 50%, they own 50%. Now, they can't kick you out as long as you want to live there. You have a life estate. But if you decide, you know what, I don't want to live here, it's too big, I don't want the maintenance, it makes me sad, I want to move in with one of my kids, so I'm going to sell this house, you're going to be giving 50% of the proceeds to your stepchildren. If your husband also has a 401k with $500,000 in it, $250,000 is going to be split between his kids, $250,000 is going to you. So blended families, again, red flag. Have really good comprehensive estate planning. You will avoid a lot of these headaches and heartaches that come up. Okay, but nuclear families, us too, right? We have our own drama. We have kids who get into it. We have kids that don't like each other. So it applies to all of us, but particularly blended families. What does the executor or the administrator do? What are their job? Well, like I said, gather all the assets, liquidate them, and start distributing them to the beneficiaries after you've gone through the whole creditor process. So if you're going through the probate courts, you first have to deal with any creditors that pop up, then you distribute the funds. If whatever's left, if you are able to, if you have a trust in place and you're able to handle an estate through the trust, for the most part, you can avoid these creditors. Okay, so that's another advantage of a trust. Sale of real estate, as soon as an executor or administrator is appointed, the house can be listed for sale, can be put up for sale. And then we put that money actually is wired from the title company to the bank account for the estate. Okay, so it's not going to the beneficiary's bank account. It's not going to the executor's personal bank account. There'll need to be an account for the estate set up specifically. The money will be wired there. And then it's the executor or administrator's job to get the proper amounts to each beneficiary once it's there. What about out-of-state real estate? I'll tell you right now, if you own real estate in more states than Texas, which a lot of people do these days in DFW, because a lot of my clients do, because again, people have moved in here from just everywhere. And, I've got clients with they still own the condo on the beach in California, or they still have, a rent home in New Jersey, or they've got the family farm in Pennsylvania. And so I have a lot of clients with Texas real estate and out-of-state real estate. You really want to trust, because what's going to happen is if you don't have a trust, first, your family is going to probate in Texas, okay, so that they get the right to be your executor in Texas and sell the Texas property. Then they are going to go to, let's say, Michigan or, Alabama, wherever else you have property, Oklahoma, and they're going to have to hire an attorney there and do what's called an ancillary probate through that state, because a Texas judge does not have the legal authority to sell, to order a sale of property outside of the state of Texas. Just judge doesn't have jurisdiction over it. So you got to get with that judge in Florida, or that judge in Kansas, or that judge in California. So that's a double probate. A trust solves all that. So if you own property in more than one state, please seriously consider a trust. Other complications, determining who is administrator if no will, and multiple people have priority. Also, some people have wills that are very outdated. I mean, and good thing they come in usually, but I have clients coming in with wills from 1986, and their kids were 4, and they barely owned anything, and now they're worth $3 million, and their kids are 30 something, and they have grandkids, and the people they put as the executors, they're not even alive anymore. And so if we have problems with the will, maybe it's an out-of-state will, maybe it's very outdated, and we don't have the people we have named as executors, maybe they're already deceased, maybe they're 95 and just not up to it. So these are some other things that can come up, but doing a very comprehensive estate plan and having it reviewed. We give our clients a free review every 2 years. So everybody that gets an estate plan from me gets a complimentary review every 2 years. But I tell people in general, at least every 5 years, get with your estate planning professional and do a review, because it's amazing how we don't think that it does, but when you start looking at things, how much can change in 3 or 4 or 5 years. It's a lot. Attorney's fees, that can be all over the board. But average cost right now to probate a will in DFW is about $3,500. Average price to probate in a state without a will is probably around $6,000 here in the DFW area. And so it's always less expensive to set up an estate plan, and it's always easier down the road and less stressful. You take those expenses I just told you, and you take a married couple, you're doing it times 2. You eventually probate 2 wills. So you're spending $7,000, $8,000. Or if they don't have wills, you're spending $12,000, $13,000. Okay. So always cheaper and less stressful to have that good plan in place. What exactly is a revocable living trust, which is what helps us avoid probate? Think of it like a treasure chest or a box. Okay. We put our things, our titled assets, our accounts, our property into that box. And when we pass away, it can do numerous things. Helping us avoid probate is possibly most noteworthy. Also, avoiding the federal estate tax is also something it can help us do. And then lastly, one of the great things that a trust can do that nothing else can do in the US that I'm aware of, or in the state of Texas, it can allow us to leave money to beneficiaries out in time. So rather than, I died unexpectedly, and now my 19-year-old son is going to get $500,000, in 2 months. We can have a trust that says, my kid or my grandkid doesn't get a dime until they're 25 or until they're 28, or, this person is terrible at managing money, so they're going to get a certain amount per year for 10 years. We're not just going to hand them large sums of money because they're not mature, or they have a poor track record of handling money, or maybe they have, gambling issues, chemical dependency issues, things like that. And so with the trust, we have the trustors, or the people who set up the trust. So let's say a married couple, for example, although it could be a single person. The trustees are going to be those same people while they're alive and mentally well. So the married couple will manage the trust together. And then the money is for their benefit, all the assets, of course, while they're alive. Once they pass away, successor trustees come in who are already named, and they handle things. And we have the new beneficiaries, maybe the adult children, for example, who receive the assets. So how does a revocable trust work? Again, we have the trustors while they're alive and mentally well. They're in charge of everything. I have a lot of people ask me, what is the downside to a revocable trust? I know there's a downside, just tell me what it is. I see zero downside whatsoever, and I see heavy upside to a revocable trust. Irrevocable is different. It's beyond the scope of today. There's some downside to that, but revocable, I see no downside. And then once a a trustor, a trustee, if they become mentally incapacitated, the successor trustee can step up and start managing the assets and trust, but they are still for the benefit of that trustor who's mentally incapacitated. They're still the beneficiary. Okay, it's just somebody else is managing it on their behalf. And then once that person dies, so once that trustor dies, then the beneficiary becomes maybe, let's say, the next generation, for example. But I've had clients, they put in, I mean, obviously some people don't have kids, and so they put in charitable organizations or they put in other family members, but typically we see the next generation become the beneficiaries. And so all of this is done, mind you, without going to court once. You don't have to hire an attorney for a single second if you don't want to. Most of my clients' families will come consult with me, and I'll guide them on kind of what they need to do. I'll give them an hour consult for free and kind of give them a roadmap of what they need to do. And usually they just go do it. Sometimes they want extra help and they'll hire me to help them, because they want some extra help, but they certainly don't have to do that. Much quicker, much cheaper, much less stressful than going to probate court. Why use a trust? Well, gosh, I think I just talked about that for 20 minutes. Avoid probate, avoid multiple probates, avoid, family problems, avoid the federal estate tax, avoid stress, avoid the cost. There's so many reasons. So Smith Revocable Trust, how it works during different time periods. So when both spouses are alive, they're in control of it. When one spouse is deceased, then that surviving spouse is in control of it. When both spouses pass, then the successor trustee is in control. Now, frequently a successor trustee will be an adult child, but it doesn't have to be. I have clients that for various reasons pick other people to do it, and that's absolutely fine. Hey, first spouse's death, second spouse's death. Okay, so trust provisions. Like I said, different things we can do with the trust. Avoid probate court, avoid the federal estate tax, treat each beneficiary differently depending on financial maturity, age, if they have chemical dependency type issues, if they're in a rocky marriage, lots of things we can do to set up to help people in a trust that we can't do with anything else. Also for the special needs families, families with the special needs, kids or grandkids, it's very critical to get a special needs trust in place so that your special needs loved one can maintain their Social Security disability and their Medicaid. Because what happens is this: if I'm special needs and I'm on Social Security disability, I'm on Medicaid, and I receive I had this happen a few years ago, so sad. This lady received a $55,000 inheritance from her father. She got kicked off of it, kicked off of Medicaid, kicked off of Social Security disability, had to spend that $55,000 down, just kept paying bills, spend it down to $2,000. Then she had to pay me to reapply for Medicaid and another attorney to reapply for Social Security disability. So if that money is routed into a trust, in a very specific, appropriate trust, that special needs loved one can keep all their benefits from the government, and they can have a trustee that can buy certain things for them out of the trust. So if you have a special needs kid or a grandkid, or if you have a close friend or family member who does, you really need to have them call us. We'll just have a conversation about it. I'll explain to them what it is that can be done, and then they can make a decision. But even if it's a younger, if it's a minor who's special needs, it's still important, because what if the parents pass away before that minor is an adult, right? We still want that special needs trust set up so they can still qualify for their Medicaid, their Social Security disability, and then we have maybe like a sibling or an aunt and uncle who control the trust and help buy other things for them that are allowed by law. Okay. Now, I want you to kind of think about this quickly. And so this is not a happy thought, but hey, this is what happens when a loved one dies. I don't think you came here for lollipops and rainbows and ice cream, right? Came here for the kind of the truth of things. But just briefly think, what if something happens to you? What if in the next 48 hours, you're in a terrible accident, you have a bad medical episode and you pass away, or your spouse passes away, or your parent passes away? What is the aftermath going to look like for your family? Right now, do you feel really, really good about how your family's ability to say, here's the estate plan, let's get it, let's go talk to the attorney, and things are going to work out really nice and smooth? Or do you think that there may be some problems and maybe even some major problems? And so what I would encourage you to do is, if you think that you don't feel 100% confident in what you have in place right now, we do offer a complimentary personal consultation for up to an hour. So the first consultation is always on the house for up to an hour. And so I want to encourage you guys to take advantage of that. The worst thing that will happen is you'll spend an hour probably learning a lot of things and getting some really good ideas on directions that you could head in your estate plan. The best thing that could happen is you could end up with a really good estate plan that puts you and your family in a really good position for when these things happen. So I want to encourage you guys to take advantage of that. I previously, prior to COVID, I really wanted and preferred to meet with people in person. I still think it's the best way to do business. It's kind of old fashioned, but I like it. Obviously, COVID made us completely reorient ourselves on that. All of us, right? We all had to get used to these new ways of doing things through video and so forth. So we went through a period where we did a lot of Zoom and phone consultations. Now, with a lot of people having the vaccine, we're getting back to where a lot of people who come to see me want to come back in person. So at this point, it's just up to you if you'd like to take advantage of this. I really like meeting in person. If you feel like that's just not what I want to do right now, I completely respect that too, and we can go another route. But okay, that being said, guys, I hope that was informative, and I want to pause and see if we can answer some questions now. Okay, so I'm not I'm not high tech here, but let me do my best, guys. Okay.
Oh, I can stop your screen share. It's okay, Brandon.
Okay, perfect.
Perfect. And let me add myself so we can, there we go. Hi. All right. As always, lots of good information, things that really make me think. We've got some comments that lead to what I think are good questions. And questions. So let's start going through this. So someone stating they lost their husband in April. They were so glad that they had a will set up. Even with COVID, it was an easy process, had a power of attorney. It allowed them to grant her husband's wishes, and it was definitely worth what they spent on it. She also the same person also stated that her parents had no estate plans, and it was an absolute disaster.
Yeah, all good. I mean, I see this every day in my practice. Very good points. Yes.
Yeah. Okay, so I am going to read a comment, but then ask a question afterwards, because the comment, I think, leads to this question. Okay. So another person stated they had a problem with the bank wanting to give access to the funds for their mother, and that they had a POA drafted by an attorney and everything was in order because the bank obviously accepted it. They said, had we created it ourselves through an online service, they were confident it would have been denied by the bank. So that brings up a really good question, in that, you know, what is your opinion? There's a ton of different services now online where you can go and fill this in or do it yourself. What really is the effectiveness of using something like that?
Yeah, great question and good point. So number one, let me just acknowledge that my comments here are going to be self-serving. As an estate planning attorney, I have to approach websites that sell estate planning documents kind of as the enemy, right? So let me just acknowledge that, get it out of the way. But let me also tell you that it's kind of like this. If my plan for my health, my game plan for my life health, now I'm 46, so I'm getting into middle age and all that, is I'm just going to get on WebMD and kind of diagnose myself. And then I'm going to go to Walgreens and buy some over-the-counter products to treat myself. Probably at some point that's going to fail. If I'm not having my blood drawn by the doctor, the lab's not analyzing, I'm not being told, look, your cholesterol is high, we need to take a pill, you need to lose some weight. And so when you get online and you do these online documents, you're really playing Russian roulette with your estate plan. And what we see are several things. Number one, sometimes the documents are just flat out not correct. They're just not right.
Right.
Other times they have the potential to be correct, but they are not executed with the proper formalities of law. And so they're defective because of that. But we've seen lots of disasters from that. And the net effect of it is that that person would have been better off maybe just doing nothing, and so to put in a little bit of money into a good estate plan is always going to pay off in the end, because you're going to save a lot of money on the tail end of things. And I have a lot of clients, they tell me, look, Brandon, the big thing is not, the $3,000 or $4,000 that my family saves when I die. The big thing is, I don't want this to be a big hassle. I don't want it to be stressful for my family or for me if I'm doing this for my spouse. And I don't want my kids or my stepkids and my kids fighting with their stepmom because we didn't do things the right way. So it just I can't emphasize enough to put some money into the estate plan, to get it done right, and to have that peace of mind that it's done right. That's what's going to pay off in the long run. Just like if I go to my doctor every year, I get checked up, I take the medications they tell me I need to take, I follow their directions, and I exercise, my physical health is going to be better. It's the same thing with estate planning health.
Okay. And I would think it would be hard too for a program like that online to know all the nuances of, every situation is different and every person's needs are different. It would be hard, I would think, for a computer program to really understand what I need, as opposed to working with someone.
Yeah, it's a big gamble. It's a real big gamble.
Okay, great. Okay, so the question is, what is the cost of excuse me, what is the cost of a revocable trust for a married couple? And actually, I think the blanket question is what is the cost of a revocable trust, and are there different factors that would affect that cost?
Yeah, so a couple of things. Number one, for a lot of our clients, we do packages, and all of our revocable trusts also come with what are called pour-over wills, which I don't want to get off into a tangent on that, but they come with pour-over wills, which are necessary. And then oftentimes clients will add a package with powers of attorney, so that they're also getting the documents that apply if they become incapacitated. But if somebody comes in and says, look, I already have everything, it's great, it's done, but I just want to add a trust and that's all, you're probably looking at spending between $1,500 and $2,000, depending on how complex or non-complex that revocable trust is.
Right.
But most of my clients get packages. A lot of these packages for a married couple are going to be in the $3,800 to $4,800 range. That's if you're getting a trust with all the powers of attorney and the pour-over wills. This is always cheaper than going to probate court, and it is always much less stressful than having to go through the court system when somebody passes away or when somebody becomes mentally incapacitated. Because if somebody becomes mentally incapacitated as an adult and we don't have the proper powers of attorney, we don't have them, or they're outdated, or they're from another state, they don't work here, then you're going to be going to probate court for guardianship. And you're going to be, in a best case scenario, you're going to be spending, $6,000-7,000. If you end up in a knockdown drag out with a sibling or with a step parent or a step sibling, you could be spending $20,000-25,000 in litigation fees. So real critical to have those POAs, and that's kind of our pricing range. We also have last will and testament packages, where they can be around $1,800 for a couple, where everybody gets a last will and testament, and then everybody gets our power of attorney package, which is 7 powers of attorney.
Okay, fantastic. So discussing cost, this is not a question that came up, but it's a relevant question for myself, so I'm going to ask it. For those of us who don't have $4,000 to spend, are there payment options? Can it be spread out? What are our options as far as paying is concerned?
Yeah, so I will work with people on payments. I mean, especially if it's somebody that's, I mean, just the best way I can put this, somebody that's really nice and just says, hey, look, I really want to get this done. But I don't have all this money right now. Let's say they're not pushy about it. I'll just say, hey, tell me kind of, here's an idea, but if you can't do that, tell me what you can do. But I guess the catch to it is we won't actually have them come in and sign the documents until all the payments are made. So somebody can get, somebody could say, look, let me give you 25% every pay period. And then in 2 months, you'll be paid up. And then we'll get the documents prepared. We'll have them ready. And then once they're ready to make that last payment, we'll have them come in and sign the documents that day. So we'll work with people, but we don't have them sign the documents until the last payment is made. But just the unfortunate fact is there's people out there that will never come back and pay you. I've learned that the hard way when I was younger. So we hold on to the documents until we get that last payment.
Well, and that makes tons of sense. And it's great to know that, and for everyone in the room that there's an option like that available.
Sure.
And makes perfect sense. Can't execute it till it's paid for.
Absolutely.
Okay, so we did have someone ask, they said that their husband passed in January 2021. I'm sorry to hear that. They wanted to know if the 2020 tax return is done normal, as if he was still living, because he would have still been living in 2020.
Yes. Well, number one, hello, Paulette. Paulette's one of my favorite clients, by the way. So her and her son as well, Peter. Yeah, so for the 2020 tax return, that will be done as normal. And actually, the 2021 really will too, because even if somebody passes on January the 3rd, whatever income they may have brought in that month, we need to treat that as normal for that year. So yeah, 2020 tax return, income tax return will be normal. So will 2021. And then of course, 2022 is where it will change for Paulette. And then also Paulette, if you need a recommendation on a CPA, give us a call. We'll give you one.
Okay. You mentioned estate tax return.
Yes. Yeah, you're going to need that for the year. Within 9 months of the person dying, you also need to do an estate tax return. Now, here's the thing right now, and so everybody's going to laugh at this, myself included. But right now, if you die and you leave less than $10.8 million behind, there is no estate tax.
Right.
Okay. So the vast majority of us, when we or our spouse passes away right now, we're not going to be paying the estate tax. There will not be any money actually due, but we still need to do the return to show the government how much was in the estate. So yes, within 9 months of somebody passing, we need to do that estate tax return. And again, this is just kind of like when I say that, hey, it's worth it to spend a little bit of money to get your estate plan in place. I think after somebody passes away, it's worth it to hire a CPA, spend a little bit of money on a CPA to get the proper return done.
Okay, because I didn't even know about that having to be done. So, okay.
Yeah, those things will need to be done. And again, we can recommend a CPA to you.
Okay. We went over what the cost of a trust is. Now, someone said that they're in Chicago and we're asking if you would be able to help, but you cannot help in Chicago, correct?
Yeah, so I'm right. And I am a member, as I mentioned, of the American Academy of Estate Planning Attorneys. I know we have at least 1 or 2 members in Illinois. So if this individual would like to reach out to my office and ask for a referral for Chicago, we'll see what we can do to help.
Okay. And then I got a message. Someone said they sent you a question. Yes. I did not see it. Do you want to address that one?
Well, who is that?
Barb's
who is
iPad. Came
Barb.
from Barb's iPad.
Let me see, where is that?
I don't know, because she said she sent it directly to you.
To my email? Or
No,
where?
in the chat.
Oh, in the chat.
Yeah.
Okay.
It would have red direct message next to it.
Okay. I think I'm getting to it. I'm sorry, I'm not on top
No,
of
that's
this.
okay. I didn't know, and I'm glad
Yeah,
she brought it up.
1 second, Barb. Hold on. God, why can I not make this work? Well, I do. Okay, hold on. Hey, Mitch. Okay,
Actually, hang on,
phone.
Brandon. I got this. Barb, do you want to resend that question to me and I'll read it off to him? It ended up far up in the chat. It makes it difficult to find, but we'll get that answered for you. In the meantime, while we're waiting for that question to come through, what did you mean by an outdated POA?
I sent it already.
So Barb has one. It says, if your will automatically transfers your assets into designated empty trust, including a special needs trust, does that still require probate? Is that what you wanted to know, Barb?
Yes.
Okay, so let me read this again and actually think about it deeply. If your will automatically transfers your assets into designated empty trust, including a special needs trust, does that still? Yes. So this is, I mean, there's not anything particularly wrong with this method, but I don't do it. I just don't like it. So I never do this in my practice, but some attorneys do. I think it's a little bit more old-fashioned way of doing things, but some attorneys will have a will set up, a last will and testament, and they'll include the creation of a trust in the last will and testament. And sometimes the trust is only funded on certain circumstances happening. So it may be that if XYZ doesn't happen, we never fund this trust. It's dead language in the last will and testament. But yeah, that still requires probate. Absolutely. If there's a trust created within a last will and testament, it still requires going through probate court first. Yes. Good question, because I see that from time to time.
So should I have it rewritten?
I mean, I don't want to say, you don't have to have it rewritten. I'll just tell you that's not my preferred method. And the reason it's not my preferred method is because if you just have a trust set up right out of the gate and a trust funded right out of the gate while you're still alive, your beneficiaries, whoever they may be, maybe they're your kids, they can avoid court altogether. So, I mean, I'm not going to say that you should or you have to or anything like that. I'm just going to say that's not how I like to do things. And okay. I prefer to avoid probate. I prefer to help my families avoid probate court.
Yeah, me too.
So,
can you set up a special needs trust ahead of time?
Absolutely. Oh, yeah.
Okay.
People do that all the time. Absolutely, you can.
Okay, get ready for your hour consult.
Okay, all right. I look forward to it.
Thank you.
And then, Zoe, I think you had a question about POAs and.
Yeah, what did you mean by an outdated POA?
Yeah, so that's almost a misleading thing for me to say, but when you get a power of attorney, there's never a point in time that you can say, well, in 5 years, this is not going to work, or in 8 years, this is going to be obsolete. Mm-hmm. What we do know, though, is that eventually they will be obsolete just because of the way the laws change and progress. Mm-hmm. But we don't know when that's going to be, right? We don't know if it's going to be 5 years, 10 years, 15 years. But what we've noticed in our practice is that if our clients, let's say like every 5 to 6 years, stay on top of redoing their powers of attorney, getting new ones, coming in and saying, whatever the current language is, give me that. It's been 6 years. Those clients rarely seem to have problems when they need to use them. Okay. It's when we see people coming in, 10, 12 years down the road, sometimes we have things being denied simply because the laws have changed, and now the legal department at Wells Fargo or the legal department at Charles Schwab says, I'm sorry, we don't accept this language anymore. And gotcha. So that's what I mean.
Okay. Is there a standard living trust form for the state of Texas?
I don't know. I mean, let me just say this. There are a lot of attorneys. I would say the vast majority of attorneys that I know mm-hmm. will not touch the drafting of a trust because it is so easy to mess it up. and the liability can be so high if you mess up the trust. For somebody to try and get a standard form for a last will and testament or a POA I still don't think it's a good idea, but I don't think it's absolutely crazy. I think it would be absolutely crazy to try and draft a trust on your own and to get a standard form. It just, again, there's a bunch of attorneys that will not touch a trust. And so that should tell you something. You know, if 80% of the doctors don't want to operate on knees, then maybe we should not operate on our own knee. You know what I mean? So I don't know. And if there is, I think it's a bad idea. I'll just leave it at that.
Okay. Pearl, you have your hand up. Did you have a question?
I'm sorry. Yes, I just sent the question in. It's about heirship on land property for my children. I'm trying to get them put on the property. It's in Marshall, Texas. And I'm just a little confused about what it is specifically that they need me to do. I printed up an affidavit. However, I still don't understand what I need to do when I present this information to them.
Okay, so number one, do you own that property right now?
It is grandparent owned.
Okay, and it's your parents who own it then?
Yes.
Okay, and are they alive?
No.
Okay, so what you need to do, number one, well, okay, how long ago did they pass?
20 years ago. 20 years ago plus.
Okay, did anybody probate a last will and testament for them, or was there no probate done?
No.
Okay, so you're going to have to do an affidavit of heirship. It's going to put all of their kids in the title. So whoever were the kids of your parents, I don't know how many they had, but they'll all be entitled equally. Okay. And then from there, you can deed your shares to your children. I recommend using an attorney for all of this. I don't recommend doing any of this on your own, because if you do anything a little bit incorrect, it's just not going to work. So if you want to have a consultation, I'm happy to have a consultation about it with you for free. We can talk about it, but there needs to be an affidavit of heirship that will put all of your parents' children into title. And then from there, if you'd like to deed your shares to your children as a gift, for example, then we can talk about, you can do that too, and we can talk about how to do it.
Okay. That sounds good. And yes, I do need a consultation. So
okay, well, give us a call. We're happy to do it.
Thank you so much.
Sure.
Okay, great. I'm glad we were able to get that answered. So how does a revocable trust affect income tax while you're alive?
Okay, it should not affect it, period. A revocable trust while you're alive, if you have any capital gains on assets inside of the trust, you can flow those onto your personal income tax. Okay. Obviously, once you pass away, then we're being taxed at the trust rate, okay, which is on par with high income earners. But you know, it is what it is. But while you're alive, you can flow it onto your personal income tax, and you're not going to be taxed at the trust rate.
Okay, great. Okay, so this is related to the question Barb asked you. What is the purpose of a pour-over will, and is probate still required?
Okay, so a pour-over will is this. When we have a trust, our goal is to get all of our assets connected to the trust, held in trust, so that when we pass away, everything passes through the trust and we don't have to go to court. Unfortunately, a lot of people will set up their trust, they'll fund their trust, and then they go down the road of life and they get a new bank account, or maybe they inherit a piece of property and they forget to connect it to the trust. And then let's say John Smith opens a new, investment account with Charles Schwab and puts $200,000 in there, forgets to beneficiary designate it to the trust, and then he passes away. Everything passes through the trust except for that one account, right? It can't, because it's not connected. So the pour over will, pour does not mean pour as in monetary. It means something pours out of the trust. It's a very old-fashioned term that an asset pours out of the trust, and we use the last will and testament, that pour over will, to take that one asset through the court system. And the beneficiary of that will is the trust. It's not people. So then the court will send it into trust, and it will follow the rules of the trust. So think of it like the airbag in your car, right? It's the backup system. We hope we don't get in an accident. We hope the airbag doesn't get deployed. But if that happens, we're glad the airbag is there. It's the same thing with the pour over will. We hope we keep everything in good shape with the trust, but in case we miss something, we're glad that pour over will is there to help us out.
Okay. Wow, that's a great option. See, look, Barbara Weaver is she is saying exactly what I'm thinking. Very good presentation.
Thanks,
Always
Barbara.
learn something from Brandon. I sure do. Every time I come in here, I'm like, man, I'd be a mess. Nothing like feeling like you're a mess every time you leave, but it's okay. Okay. So question, would we have to go through the attorney when we buy or sell something that is in the trust, i.e. a car or a home?
No, great question. I get asked this all the time. So every time I buy a new property or I open a new account, do I have to come and pay you to do something? And the answer is absolutely not. Okay. What I do encourage that you do is you call our office and you say, hey, look, I'm opening a new account, or I'm buying, a condo in Florida or South Padre Island, and what do I need to do here? And we'll just have a little conversation with you. It might be with me, it might be with one of my staff members who also knows how to fund. And we will not charge you for that if you're our client. And so, no, you don't have to come and pay me to do something every time you add new assets. And I get asked that a lot. That's a good question.
Yeah, that's a great question, because the first thing I thought was, gosh, the way me and my husband are, we get a new house every 5 years. So we'd be changing it constantly.
It can just be a quick check-in. Hey, this is what we're doing. What do I need to get done here? And then usually we'll just tell you, and then the client will do it, and that's it.
Fantastic. All right. Okay. Brandon, how are you doing on time? Because I have another question that came through.
Yeah, I'm fine. I think 10 more minutes.
Perfect. Okay. If an account is already stipulated with the child as the beneficiary, must it also be included in the trust, or will it also have to be included in the trust, or will it have to go through probate?
So, number one, the beneficiary designation on an account trumps everything.
Okay.
It is more powerful than the will. And if the trust is not listed as a beneficiary and somebody else is, it's not in trust. What most of my clients will do is with their accounts, if they set up a trust, they will, if it's a joint account, like a marital account, they'll put the trust as the beneficiary. So once both of them die, the successor trustee can step in and get access to it quickly. If it's an individual account, such as a retirement account, then usually they will put the spouse first. Number one, it's required by law. You can't get sneaky and take your spouse off of your retirement beneficiary designations. The spouse, you would have to sign a waiver agreeing to it. So normally we don't want to go through all that. We'll put the spouse first and the trust second on individual accounts. And then on joint accounts, we put the trust first. But whatever the case may be, whoever that person is or that entity is that's listed on the beneficiary designation, that's who's entitled to the money, period, end of story. Nobody can come in and usurp that.
Good to know.
You got to be very careful with those, because that's who's going to win. The winner is going to be the person with the beneficiary designation.
Yeah. Awesome. Okay. That looks to be the last question. Brandon, as always, like I said, I learn something every time I come. You are so incredibly knowledgeable. You really know your craft, and it definitely is a craft in this regard. There are so many moving parts and pieces. I always, sorry, does that mean that Rosemary, I'm not understanding the question. I'm thinking it might be a typo. She's asking about something
Well,
about, go ahead.
Excuse me. Hi, Brandon. You were saying the beneficiary, let's see, if they're designated the beneficiary of an account, if it's a very much of a large sum, does that mean then they will have to separately do probate on that? Since it's not in the trust? I'm just
No,
not-
so, okay, let's just say I have an account with Bank of America. Let's say it has $200,000 in it. And I have two sons, they're adults, and I leave them as the joint beneficiaries. What that means is they don't have to go to probate court to get to that money. They can they can get my death certificate once it's issued, their ID showing who they are, go to the bank, and immediately get access to their half of the funds. So if you have a beneficiary designation, it negates the necessity for probate court. Okay, and you don't have to probate the last will and testament. But look, I recommend to everybody, whether you have a trust or you don't, or you say, I'm just going to go beneficiary designate everything I have, you always want a last will and testament as a backup plan, because so
Right.
often people miss something. It's very common that this one thing, I mean, we're so busy in life, you know, we can't know everything, and a million things are going on, and oftentimes people miss something. So we always want to have the last will and testament as a backup just in case. But the beneficiary designation makes it to where the beneficiaries do not have to go through the probate court. They don't have to probate the last will and testament.
Thank you.
Yeah, absolutely.
Fantastic. All right. Okay. Like I said, excellent job. Guys, if you want to take yourselves off mute, give Brandon a round of applause. Lots of comments in chat saying it was an excellent presentation, a big help as always. These are one of our most popular Zoom and Learn. So
Good job.
thank you.
Well, hey, thank you guys so much. And, you know, this is what I do day in and day out. So this is for me to sit here and talk about this. It's second nature. It's enjoyable. And so I'm really happy I got the opportunity to educate you guys a little bit. And I hope that helps you guys make some really good decisions that will one day benefit your family down the road. Okay.
Most
Thank you.
certainly. And I was told by a little birdie at your office that anyone that was in this Zoom today, someone from McGee Law Firm is going to be reaching out to you. They have a free booklet on this topic that they would like to send you. Is that correct, Brandon? Am I getting
Yes.
that right?
Yeah. So whenever I do live presentations, which I used to do all the time until this COVID hit, we would always pass out some hard copy materials. And so we still like to get those out. So yeah, we'll absolutely be reaching out and getting you those hard copy materials that you can refer back to. Because I'm going to assume you are not going to remember everything I just said. So,
Well, and for all of those who said that they wanted to get with Brandon for one of those consultations, if you don't call them beforehand, that's an excellent time too, that you can request that when they reach out to you about doing that. They'll get you all hooked up, right?
yeah, just let us know. And if you're interested in that consultation, we're more than happy to schedule it. If you're not, that's okay too.
Yeah.
Thank you.
Great. Well, thank you
Thank
so
you,
much
guys.
once again.